pare, Carlo, che aveva chiesto la parola, che Ottavio Marzocchi abbia dato altri elementi.
That Ottavio Marzocchi has given some
Riprendevano quanto premesso questa mattina, si accinzia.
I'll be very brief. I don't want to take too much time. I wanted to start by saying that whatever has been said so far has been very interesting, but please don't fall in the trap and saying that these policies are not under the remit of the European Union. Facts give the evidence, and when there is a breaking point, and I'm referring to the economic crisis, everything is put into question. So pensions, social policies, and the white paper of the Euro Commission, the member states are pushing to it. Countries that are to negotiate the public debt have been forced to reduce the minimum wage. They have been prompted into extend the pension age. All these issues are not under the strict remit of the European Union, but whenever social policies are at stake, there's economic crisis. So it's up to us to open doors which are at the moment closed. I was referring to what Gianni was saying before. We have been talking about litigation, legal disputes, but I would like to underscore also cross-section and transversal alliances. Some individuals are not organized from the social viewpoint. So the rainbow families are a large reality, but we have other cases like the lay issues. But we are not talking about homosexual families, but also the heterosexual, so the new families, divorces, the litigations, transborder litigations. There is an increasing number of families dealing with these issues. We are trying to cooperate with some member states. I might talk of my personal issues. 7 years of transborder divorce. My divorce proceeding started when my children were 12, and I won the lawsuit when it was no longer needed. In this specific case, with Italy and Belgium, all these families were born on the ground of love, but they were faced with difficulties beyond the being same-sex or different sex. What we were saying before about the possibility to push the European institutions in speeding up the recognition of the principle of the banning of no discrimination, I think there is a common ground here. The rights on the move are not only related to mobility, but there is a continuity between what has been decided by and ruled by the Court of Justice in Strasbourg and what has been perceived by the Luxembourg Court, the European Convention of Human Rights. This morning, the recent ruling of the Court of Strasbourg was mentioned here, relating the civil partnership of same-sex couples. So the Vaianatos ruling, according to the Court of Strasbourg, member states are free to choose to introduce these unions in their order, but in doing so, they shouldn't envisage discriminations. In case of a different treatment on the ground of sexual treatment, there are differences in the states. The court of Strasbourg didn't accept the Greek justifications. The heterosexual couple can be compared to the same-sex couples, so limitations are not allowed here. According to the court, the social reality is the same, and there is a tendency to the recognition of same-sex couples unions. So the infringement of Article 14, which bans any form of discrimination, which is similar to the articles mentioned of the treaty and the Nice Treaty, and the Article 8, which ensures the right to respect private life, family life, which is the copy of the Article 7 of the Nice Treaty, which is part of the chapter respect of private life. Each human being is entitled to have the privacy of his private life and family life. And this is all related to the fact that the European Union will have to abide by the Convention of Human Rights. And being this process so long, if this will be the case, it will be possible to have private appeals in case of situations infringing fundamental rights. When it comes to marriage, the possibility to form a family, according to the Article 9, there is a distinction. On the one hand, we have the right to marry. On the other hand, we have the right to form a family, to set up a family. It is true that this is not translated into an enlargement of the competences of the European Union, but among the final provisions, there is a reference to the protection similar to the one envisaged by the Convention of Human Rights, which in any case might allow for a more extended interpretation.
Della Corte di Strasburgo relativa al caso della Grecia testimonia del movimento di questi diritti.
This is an evidence of these rights. And so we are going into an interpretation of these rights of the treaty, of the Nice Charter. But the Court of Justice will rule about it. But this is a further stimulus to the trade unions in order to support this movement. Now we have the presentation of Maria Raquel Gomez. She is shedding light on this continuous movement of these rights. Rights of protection, both on the legislative viewpoint, because he mentions the two fundamental laws issued in 2005 and 2007, and how this collective agreement can really confirm these rights. Thanks to her presentation, we can have different viewpoints. We have the effort of the collective bargaining of the industry and enterprise in order to make these rights viable and implemented within a company. But moreover, an analysis has been carried out on the collective agreements, in comparative analysis of the different collective agreements, aiming at seeing how the different protections and measures are ruled. Later on, she talks about the equality programs. And lastly, she reminds us that very recently a study on discrimination has been published based on gender identity in Spain, which shows how the LGBT population paves the way to wide-ranging researchers. This fear of being submitted to discrimination on the basis of the sexual orientation. I think we have a rich menu here, and I think she can talk about it.